Good afternoon, Your Honours. Case number IT 9517/1A, the prosecutor versus Anto Furundzija.
Mr. Furundžija, can you hear me?
Yes, Your Honor.
You may sit down. The appeals chamber will take the appearances now for the appellant.
Good afternoon, Your Honors. Luka Mishetic on behalf of the appellant Anto Furundzija.
For the respondent.
May it please Your Honors, I'm Furundzija. I appear for the prosecution with Mr. Christopher Staker and Mr. Norman Farrell. The judge hereby is the case manager.
The appeals chamber of this international tribunal is now delivering judgment in the case of the prosecutor against Anto Furundzija. Copies of the judgment, which is in writing, will be made available by the registrar to the parties towards the end of this sitting. Following the practice of this tribunal, I shall not be reading out the text of the judgment except for the operative paragraph. Save for a reading of that paragraph, I shall limit myself to introductory matters. This chamber is seized of an appeal by Mr. Anto Furundzija, brought on 22 December 1998. The appeal arises in this way. The appellant, Mr. Anto Furundzija, was indicted on 3 counts of crimes within the jurisdiction of the tribunal. At his initial appearance before the trial chamber on 19 December 1997, he pleaded not guilty to all counts of the indictment. One of the counts was subsequently withdrawn in the amended indictment. On 10 December 1998, Trial Chamber 2 of this tribunal found the appellant guilty on both remaining counts. Count 13 as a co-perpetrator of torture as a violation of the laws or customs of war. Add count 14 as an aidor and abettor of outrages upon personal dignity, including rape, as a violation of the laws or customs of war. The trial chamber sentenced the appellant to 10 years imprisonment for the conviction under count 13 and 8 years imprisonment for the conviction under count 14. Consistent with the trial chamber's disposition, the appellant is serving the sentences concurrently inter se. It is against the judgment so rendered that Mr. Furundzija now appeals. After the appeal was brought, the appellant filed a post-trial application before the Bureau for the disqualification of Judge Mumba, presiding judge at the trial, and a motion to vacate conviction and sentence and for a new trial. This application was dismissed on the ground that the determination as to the fairness of the trial was not within the Bureau's competence. The hearing of the appeal was held on 2 March 2000, and judgment was reserved to a later date. A subsequent motion regarding lack of jurisdiction on the part of the trial chamber, filed by the appellant on 8 March 2000, was rejected by the appeals chamber as being filed out of time. This afternoon I shall be doing three things. First, I shall introduce the text of the judgment of the Appeals Chamber. Secondly, I shall give a summary of the findings of the Appeals Chamber. Finally, I shall read out the disposition of the judgment of the Appeals Chamber. I reiterate that the judgment is set out in the text to be handed out. This statement is not the judgment of the Appeals Chamber except for the reading of the disposition. Today's judgment is divided into 8 sections. Section 1 sets out the procedural background of the appeal, together with the respective grounds of appeal and the reliefs sought. Section 2 addresses the preliminary matter of the standard of review on appeal. Sections 3 to 7 of the judgment discuss the appellant's 5 grounds of appeal. The final section contains the disposition. I shall now go through the main sections of the judgment. As a preliminary matter, the Appeals Chamber addresses the relevant standard of review on appeal, which was raised by the parties. The Appeals Chamber holds that its role is limited pursuant to Article 25 of the statute to correcting errors of law invalidating a decision and errors of fact which have occasioned a miscarriage of justice. With respect to errors of law, an appellant bears the burden of argument. But if the arguments do not support the contention, the Appeals Chamber may step in and, for other reasons, find in favor of the contention that there is an error of law. With respect to errors of fact, it is only where the evidence relied on by the trial chamber could not reasonably have been accepted by any reasonable person that the Appeals Chamber can substitute its own finding for that of the trial chamber. The appellant submits 5 grounds of appeal against the judgment of 10 December 1998. They are as follows. 1. That the appellant was denied the right to fair trial in violation of the statute. 2. That the evidence was insufficient to convict him on either count. 3. That the defense was prejudiced by the trial chamber's improper reliance on evidence of acts that were not charged in the indictment and which the prosecutor never identified prior to the trial as part of the charges against the appellant. 4. That presiding Judge Mumbai should have been disqualified. And 5. That the sentence imposed upon him was excessive. As for the reliefs sought on behalf of the appellant, there are 1. That he be acquitted, or in the alternative, that his convictions be reversed, or that he be granted a new trial. And 2. That in the alternative, if the Appeals Chamber affirms the conviction imposed by the trial chamber, the Appeals Chamber reduce the sentence to a term that does not exceed 6 years, including time served since the date of his original incarceration, namely 18 December 1997. I shall now mention briefly the holdings of the Appeals Chamber. As to the first ground, the Appeals Chamber holds that the appellant was not denied the right to fair trial, and that this ground must fail. As to the second ground, the Appeals Chamber holds that there has been no showing that the factual findings by the trial chamber were unreasonable on the basis of the evidence admitted at trial, and the Appeals Chamber has not been persuaded as to the existence of any legal errors which require it to intervene. Accordingly, this ground of appeal must fail. As to the third ground, the appeals chamber holds that there is no requirement that the actual evidence on which the prosecutor relies has to be included in the indictment, and that the defense was not prejudiced by the trial chamber's admission during trial of evidence in support of facts not alleged in the amended indictment. Therefore, the third ground of appeal must fail. As to the fourth ground, the appeals chamber holds that Judge Mumba, the presiding judge in the appellant's trial, was subjectively free of bias, and that there was nothing in the surrounding circumstances which objectively gave rise to an appearance of bias, and that this ground, therefore, must fail. Finally, as to the fifth ground, the appeals chamber holds that the sentence imposed upon the appellant was not excessive, and that the trial chamber exercised its discretion in accordance with the relevant provisions of the statute and rules, as well as the previous decisions of the tribunal. As a result, this ground must also fail. I shall now read the operative paragraph of the judgment of the appeals chamber. It is as follows. For the foregoing reasons, the appeals chamber unanimously rejects each ground of appeal, dismisses the appeal, and affirms the convictions and sentences, done in both English and French, the English text being authoritative. Then follow the signatures of the 5 judges. Dated this 21st day of July 2000, at The Hague, the Netherlands, Judge Haberdine, Judge Vora, and Judge Robinson append declarations to this judgment. There ends the final part of the judgment. I shall now ask the registrar to deliver copies of the judgment to the parties. There being no other business, the court stands adjourned.
All rise for the vote of the day.